Good morning and welcome to the Select Committee on Victorian Planning Provision Amendments, VC257, 267 and 274. My name is David Ettershank. I'm the Chair of the Committee and I declare open the Committee's public hearing for the inquiry into those planning provisions. Please ensure that mobile phones have been switched to silent and that background noise is minimised. I welcome any members of the public in the gallery or watching via live broadcast. I remind those in the room to be respectful of proceedings and to remain silent at all times. I would like to begin this hearing by respectfully acknowledging the Aboriginal peoples, the traditional custodians of the various lands we are gathered on today, and pay my respect to their ancestors, elders and families. I particularly welcome any elders or community members who are here today to impart their knowledge on this issue to the committee or who are watching the broadcast of these proceedings. I would just recognise that all evidence is being recorded and to the witnesses you will be provided with a proof version of the transcript following the hearing. Transcripts will ultimately be made public and posted on the committee's website. For the Hansard record, can you please state your names and the organisations you are appearing on behalf of? Thank you.
Patrick Fensham, the Planning Institute of Australia, Victorian Division.
Jane Keddy, Planning Institute of Australia, Victorian Division.
Mark Shepherd, Victoria Planning and Environmental Law Institute Association, I'm sorry.
Welcome. I should also say sorry that all evidence taken is protected by parliamentary privilege as provided by the Constitution Act of 1975 and provisions of the Legislative Council standing orders. Therefore, the information you provide during the hearing is protected by law. You are protected against any action for what you say during this hearing, but if you go elsewhere and repeat the same things, those comments may not be protected by privilege. Any deliberately false, misleading evidence to the committee may be considered a contempt of Parliament. We'll leave that there and I might just go along the table and get the committee members to introduce themselves.
Georgie Crozier.
David Davis.
Bev MacArthur.
Sarah Mansfield.
Ryan Batchelor.
Sheena Watt.
John Berger.
Great. I'd invite you, if you would, to just some opening statements. Perhaps just if you could limit it to sort of 10 minutes each, that'd be terrific.
Okay, great, thank you. I'll speak on behalf of the Planning Institute first and then Mark will speak on behalf of his organisation. Planning Institute of Australia is the national body representing planning and the planning profession. The Victorian Division represents over 1,300 planners. Our members work in public practice as part of both state and local government as well as affiliated agencies, and in private practice serving the development industry as well as government clients. Our membership includes planners from both regional and metropolitan areas, and we come at this without a vested interest. We advocate for the delivery of planning outcomes that serve the public interest. And we very much appreciate the opportunity to appear before the inquiry. So what I was going to do is run through some, say, 9 relevant principles to the matters that you're considering. And they're non-exhaustive. We could go on with others, but limiting it to 9. And then our quick reflection on the planning controls which you're considering or the reforms you're considering. And then, of course, we can elaborate on any in questions that follow. So the first point we'd make is that planning reform, in our view, should be justified by a clear strategic focus that meets planning objectives. And notwithstanding Plan for Victoria, which followed these planning reform items, we're not persuaded that there is a really joined up strategy here that shows how the reforms work together to focus on the key issue of development in well-located places, okay? So that's the first point. Second point, changes and updates to planning controls which these reforms imply are important. They provide the capacity for the market to provide additional housing. They don't guarantee delivery. of the housing, but they are an important marker for the market. And we certainly support the planning reform intent of the government in relation to the three gazetted amendments, VC257, VC267 and VC274. But intent is different from detail. The third point we'd make is that planning for additional housing should focus on well-located areas, and there's been a long-standing planning aim, which you've probably heard about, which is for 70% of development in the established parts of Melbourne and 30% on the urban fringes or in greenfield areas. And the activity centres, which are part of the government's program, are an important focus to achieve this 70-30 aspiration. So the intent here again is supported and notable, and the focus on activity centres as the well-located areas to support housing and development and achieve the 70-30 split is appropriate. But we are concerned that because the reforms have not been sufficiently strategically justified and there's a limit to the evidence base, that they may work in contradictory or unforeseen ways, and that they won't necessarily increase or accelerate housing in well-located areas. In fact, because VC267 applies uniformly across the state in residential zones, it may encourage quite intense development in not well-located areas, and we risk underdevelopment actually in some areas where we'd prefer to see development. So that's been a consideration of ours. Getting into the detail, our fourth point here is that the use of acceptable or conservative deemed to comply codes or provisions within a performance-based assessment system is appropriate. And we might come to the detail if committee members are interested about this point later. But in the case of VC267 in particular, the standards or codes that have been included as deemed to comply, we don't consider them conservative. We consider that they've been dialed up from the discretionary standards which previously applied, and some standards have been removed completely. So we're talking about more permissive standards, but an easier pathway to approval for those standards. Okay, so in our view, this represents a misapplication of the idea of deemed to comply within a performance-based system. Fifth point, good design is fundamental to the social licence for planning and development. So fair point, and good design with climate resilient housing, we see it as fundamental to this social licence. But we're not convinced that the gazetted amendments, again VC267 in particular, sufficiently support good built form and design. There are no obvious levers for design quality. And under VC267 and the deemed to comply provisions, with the removal of appeal rights, we need to be confident that we can live with the repeated occurrence of the worst outcome that these controls will deliver. Item number 6, though a cherished and unique aspect of Victoria's planning system, the removal of third-party rights for engagement and or appeal can be appropriate in certain clear circumstances, and we'd say that they are where there's a specific, clearly articulated and strategically justified matter of state-level significance, where there's been a transparent and robust engagement with the community about the on-ground outcomes and the controls have been established with a democratic mandate, and there's a demonstrably low impact from those controls. So the development would be relatively non-controversial. So we know that VC267 removes appeal rights and development approved this way through deemed to comply pathways. We don't consider that's necessarily state significant. They won't necessarily have been subject to on-the-ground local testing, and because the standards have been dialed up, we're not convinced that they're low impact. So we don't think that they meet those tests necessarily for the removal of appeal rights. The seventh point, a mandated contribution to social and affordable housing is the best way for planning to make a meaningful contribution to affordability. So we don't see that in the controls yet. There's some discussion about it in Plan for Victoria. So the intent of these controls for affordability is missing the key aspect, which is the need for a mandated contribution to provide housing, to put housing within the reach of the estimated 10 to 15% of households in rental stress. Point number 8, Engagement with experts and evidence-based debate is critical to understanding whether the planning reforms are likely to work and whether they will therefore achieve their objectives. And we've been disappointed with the failure on VC267 in particular to acknowledge expert views and take those views into account. And if we draw attention to the difference in the process by which this new code was introduced and the processes that underpinned previous code introduction, where there was meaningful, thorough and transparent review of each aspect by preeminent users of the system. So we haven't seen modelling, testing and evidence on the impact of the reforms, and that hasn't been publicly aired, although there may have been some undertaken, and we believe there was. So perhaps haste has been prioritised over a demonstration of good planning principles and processes in this case. Now, the final point, just before closing comment, is as statutory law, the devil is always in the detail. So the outcomes are guided by what is in the controls, not just the intent, and that was a point I made earlier on. So I can understand that you as inquiry members here are getting your head around the planning detail in a pretty rapid way, but it's important to separate the idea of intent from planning detail. And maybe we can help you with the detail. We're the experts in this case. So look, just in concluding, in relation to the specific amendments which are subject to this inquiry, PIA in Victoria believe that while VC257 and VC274 could certainly benefit from further iterative improvements and other potentially better options could be explored, the controls themselves are not inherently flawed. And as David and Jane will probably point out, they're not yet applying in place in any case. We're not necessarily persuaded that in themselves they will achieve their objectives, but they're not inherently flawed. VC267, we believe, has been flawed from conception in seeking to codify a set of controls that were designed as discretionary. It's PIA's view that VC267 works against both the stated ambitions of the reform agenda in delivering more affordable, sustainable and well-located housing and some of the objectives of planning, as well as failing to recognise principles of good planning and design. So we're happy to take questions and look forward to the discussion on the detail of the amendments. Thank you.
Thank you, Mr. Fensham. Mr. Shepherd.
Thank you, and thanks for the opportunity to speak to you. I'm going to say a few words about what VPLA is, and then I'll go through our view of the positives and the negatives in relation to these amendments. So VPLA is a little different to PIA. We do have planners as part of our membership, but we're in fact a multidisciplinary association. So our members are drawn from all of the professions that are involved in the planning and environment fields. So that includes designers, engineers, planning lawyers, ecologists, heritage architects, and so on. Another key difference is that our focus primarily is on professional development and networking. We're not a lobby group. However, we are regularly asked to provide advice and submissions on matters of policy and implementation because our members do have an extensive store of knowledge and experience. Just by way of beginning, I wanted to just frame what these amendments do and don't do, and apologies, I'm sure I'll be telling you things you already know, but it's been important to the way we've approached this. So VC257 and VC274, of course, introduce new instruments into the VPPs, but they don't apply them to specific areas of land. And they're also, with the exception of the housing and choice and transport zone, they're relatively flexible tools. So it's difficult to assess them in the abstract, and really it's their application to particular pieces of land where there needs to be careful scrutiny if they're being used appropriately. VC267, which introduces the townhouse code, of course is different in the sense that it does apply that code to residentially zoned land. But what's important to understand is that it doesn't change where medium density housing can happen, and it doesn't change the height that can be achieved in those areas. So where medium density housing can happen and the height of that development is already governed by the zones and not changed by the townhouse code. So what are the positives of these amendments? Well, our view is that they do have the potential to result in increased infill housing and affordability in the broader sense. And what I mean by that is not the technical sense of meeting specific cohorts of need, but the broader sense on the basis that increased supply is considered to result in lower prices, and of course apartments in the same area as houses are generally cheaper than those houses. How will they do that? Well, a key factor here is certainty. I can't tell you how many times I've heard from developers that a key factor in a decision they make about whether to invest in an area and develop in that area is certainty. The unknown of the system that existed prior to the introduction of the Townhouse Code meant a high degree of risk for developers, a lot of time spent seeking to get an approval, and a lot of costs associated with that approval. And inevitably those downsides end up in increased prices for housing. So the fundamental precept of much of these amendments, which is to increase the certainty that's available to developers, is key to providing more development more quickly and more cheaply. In terms of the objectives of planning in the state, which I'm sure you've been thinking about and hearing about a lot over the course of this hearing, our view is that these amendments will enable a fairer state by providing, or enabling I should say, more diverse housing in well-serviced locations. They will enable a more economic state by reducing the need for infrastructure in growth areas. They'll enable a more sustainable state, in part, through increased use of public transport and active transport. And they'll enable a more efficient living environment by reducing travel times. But it's not all roses. There are some issues with these amendments. They're not perfect. We've identified a number of negatives. I'm sure the list that we've identified isn't comprehensive, but just to go through some of the matters that we've identified. You'll have heard of the Caspi Council ESD policies, I'm sure, and it does seem to us that this is a retrograde step to remove the effect of those local policies on development. There is certainly a risk that there will be a considerable number of applications to VCAT around declarations about compliance and potentially cancellations. Clearly, there's been a lot of investment of time and energy into amendments that are currently on foot, which will need to be abandoned as a result of these amendments. There are issues to do with landscaping. The tree canopy standard in the Townhouse Code doesn't at face value align with the standard that's been set by Plan for Victoria, and nor does it address tree removal. I've read other submissions, and I agree with those submissions that the housing choice and transport zone could result in underdevelopment because it doesn't offer the same level of certainty as the Townhouse Code. And I also accept the submission that have been made by others that there is potentially a risk around the lack of consideration of potential hazards, flooding and the like. So there are some issues with these amendments, there's no doubt about that. Your decision, of course, is what to do about that, and I don't know what options you have available to you. But what I would say is that our view is that this is important reform, it's needed reform. We need to find a way to contribute to increasing housing supply. Of course, this isn't a magic bullet when it comes to housing supply. There's a whole range of other factors that are not within the purview of the planning system. But it's important for the planning system to do what it can. Our view is that the issues that we've identified and others have identified are fixable. They mainly relate to the Townhouse Code. It's not uncommon for instruments to be introduced into the planning system and then for there to be a need for a fix-up amendment, as they're referred to, once it's understood exactly what the consequences are. It's also impossible to predict all of the consequences. Planning and development is a very complex business. And so even if 10 years had been taken and every single expert had been consulted, it still wouldn't have been perfect. It might have been closer to perfect, but it still wouldn't have been perfect. And so the idea of putting the townhouse code into the system, very closely monitoring its effects and its consequences, and then taking the opportunity to refine it, to us is the appropriate way forward. I'll just finish with some comments on the last question which you're considering, what else could be done to meet housing needs. Our view is that there needs to be a review of the application of the residential zones, so where the NRZ, for example, is applied, so that that aligns with the new townhouse code. There are, of course, a range of non-planning measures that government can take, and you know these: taxes and charges. Government can deliver more housing itself. There can be greater utilisation of surplus government land.
Yes.
There are alternatives to stamp duty. And of course, modular and prefabricated housing is an opportunity that's currently untapped. So those are just some of the other ways in which government could help to meet the housing needs of the state. Thank you.
Thank you very much. Appreciate that. Let's move into questions, and I'll kick off. Could I ask Mr. Fensham or Ms. Keddy, my understanding is that in terms of your submission, in terms of 257 and 274, reasonably relaxed, there are issues there, but the key to your concerns is VC267. Would that be a reasonable assumption?
Yeah,
Okay.
that's very reasonable.
I'm interested in the interrelationship between the amendments and GC252, and in particular in the context of the turning off of, or the exemptions to Section 55. As I understand, in terms of notification and such like, it's subject to those local schedules. Can you tell us what does that mean in terms of what the government's proclaimed in terms of notification and appeal rights, and then any other comments about the local schedules?
So you're talking about the local schedules in Clause 55?
In GC 252, there's a truckload of local schedules, I believe.
Oh, the follow-up
Yep.
amendment that switched off
Yes.
all of those local schedules to align the standards where the standard no longer existed. We have raised in our submission that issue around the switching off, if you like, and the deletion of some of the standards that existed previously in the schedules to the residential zones. It is a concern in terms of the process that's been undertaken. A lot of those schedules were introduced following extensive engagement with communities, independent reviews by panels, and direction from the state government about the tools that should be used to implement strategic work. So certainly the switching off of those is an issue that we've raised in our submission, yeah.
And in terms of the committee's heard evidence about the fact that rights to both notification and appeal has not been affected. I'm having trouble understanding that proposition in terms of the relationship between, I think it's 257 or it might be 267 and the local area schedules, because as I understand it, it's only where they're switched on by local area schedules. Is that correct?
Are you talking about the housing choice and transport zone?
I think it could be both HCS and also the BFO.
Yeah, okay, so there's probably a distinction to be made. A housing choice and transport zone, which is the zone which would apply to the catchments, that in itself as a zone retains the notice and review rights that exist in most residential zones. However, and this is where all those different parts of the reform process need to be viewed together, because you can say that the housing choice and transport zone doesn't change any of the notice and appeal rights. However, clause 55 changes, so VC267, which is the form of development and the actual the building of that development within that area is switched off for the housing choice and transport zone, the same as every other residential zone across the state. So, so while the housing choice and transport zone doesn't switch it off, the VC267 does switch it off.
Okay. And does the BFO exempt applications from the standard notice and review provisions of the Act?
It has the ability to do so,
Right.
but again, that's not unusual. So a lot of that potential and indeed the default even is not in areas where that detailed planning's been undertaken. That's not an anomaly in our existing system. So if you think about some of the commercial zones, some of the activity centre zones, even things like DDOs, a lot of those already have the ability to switch notice and review on and off, which again, once you've been through that process of strategic planning, you've had that conversation with the community, you want to provide the certainty for the development industry around what's going to happen. Switching off those notice and review rights is a not unusual part of the process in those areas.
In your submission, you state that 267 appears to undermine other important parts of reform, in particular the activity centre program. Could you elaborate a bit on that for the committee, please?
It's the point that Jane's just made, and you can elaborate. Do you want to
Yeah,
talk to
sure.
that point?
Look, the key concern that we have is the activity centre program is really focused on two different areas, if you like. So we have the key what's called the activity centre core. So that tends to be the commercially zoned land, and then we have the walkable catchments, now the housing choice and transport zone areas around. And those are the areas where we really need to see that significant shift in terms of the type of development that we're seeing, because those are the areas where we have the capacity to really make a difference in terms of the density and getting those houses in those areas close to services and facilities. Now, we certainly have some concerns, and we haven't seen any kind of modelling and testing to I guess, alleviate those concerns, that the introduction of a code which provides a really easy pathway, if you like, to delivering kind of 3-4 townhouses on a lot, as opposed to encouraging the kind of consolidation that allows you to get better urban design and better density and better landscaping within those walkable catchments, that's disincentivised to a degree by the introduction of the code. And so we'd really like to see maybe a greater consideration of the type of code that you might want to see in those walkable catchments that's really designed to deliver that kind of density well, versus the kind of code that you might see in other areas that are not well located. And that's a nuance that I'm not sure is played out in the reform to date. And it is, we think, a really significant risk that we'll see the situation that we have, and you can see it around some activity centres that we have at the moment, where you just have endless amounts of kind of strata-titled villa units all around these activity centres, and that really
ugly and hideous.
And it really compromises the ability for us to actually deliver the density that we need in those areas to meet the housing needs and to deal with things like the climate crisis.
And it does speak to the issue that perhaps Mark's raised a little bit about the planning that is required in those catchment areas, because that's where there's some community anxiety about change. But it's a big advance in the reform to start thinking just beyond the heart or the core of these places and think, well, how do these catchment areas contribute to this as a walkable area, as a 20-minute neighbourhood, for using that phrase. So the planning needs to be good in these places, because it's the flagship idea of density and achieving the 70-30. So as Jane's pointed out, our risk is that the code undermines the possibilities for really good design outcomes in those places, And it does point to some of the other levers that might be missing in the agenda around, land assembly by government intervention to make better precincts which can be integrated with housing development of different densities, infrastructure funding and charging in those areas to provide new open space or to provide new facilities. So that's the flip side, if you like, of the focus on the controls themselves and making it more certain and more easier. It's also a consideration of what the outcomes might be.
Terrific. Thank you very much. Mr Davis.
Can I thank the three of you for providing evidence today? And I think what you've said has been interesting in each case. I want to start at a very high level first and ask each of you, one of the criticisms of this process has been that there's not been proper engagement with communities, councils. A couple of the council submissions are very clear on that. Various community groups have made that clear to me and to others on the committee. Good practice, best practice planning deeply involves community engagement, and communities have a right to have a say in their own future. Am I unreasonable in saying those points? Am I correct in saying best practice planning involves that engagement, and communities have a right, a democratic right, to have a say in their future?
I'm happy to answer first, Mr.
Yeah,
Davis.
go.
I think it depends on the amendment. So it is not at all uncommon for the introduction of new instruments into the VPPs, such as the Housing Choice and Transport Zone or the Precinct Zone or the Built Form Overlay, but not their application to specific pieces of land. It's not uncommon for that introduction to occur without broad-scale community consultation. And that's because it doesn't apply, it may never apply to the area where they live. So it's a fairly abstract notion, I think, for communities. The application of the activity centre provisions, the built form overlay and the Housing Choice and Transport Zone to a particular activity centre, as we've seen recently, it is entirely appropriate for there to be considerable community consultation on that. And there obviously has been some consultation, and I won't offer an opinion about that.
Or there hasn't on, for example, the catchment zones, for example, on the catchment zones. It's been...
No, it hasn't.
No.
It's been selective.
As I understand, that's not part of this inquiry. The Townhouse Code is also a very technical change to the planning system, and one that is broad brush rather than area specific. I think if there's been a failing of consultation on that, it's been the failure to engage more with councils. I think that's where the value would have been, with more engagement with councils over a longer period of time.
So just to continue though, more bluntly, if you live in an area, you should have a say in its future.
Yes, you should.
Thank you.
I broadly agree with Mark in terms of the principles around the introduction of a tool, and I do think for both organisations appearing today, there's a really clear distinction between what those two gazettals did in terms of bringing in place a tool and then the application of the tool. And it's a really important distinction in terms of the role of the community and the appropriateness of engagement on those. I think the code, will probably have a slightly different perspective on that. Our view is that the code that's been gazetted under 267 is really, the scope of the changes really essentially means that we've got a new code. So we have a new residential code for the state. We're absolutely of the opinion that the code needed reform, and it's a really good thing that we've got the reform. But certainly you could contrast the process that's occurred with the introduction of this code with the process that occurred with the introduction of Res Code or the Good Design Guide or the previous residential codes that we've had before.
It's a lot more engagement.
And you would see that there was much broader engagement. There was detailed expert reviews that tested and went through every standard to make sure that there were no unintended consequences of the introduction of that new code. So certainly, previous code introductions have allowed the community to raise issues that were then considered by experts and advice provided in terms of whether those the standards as proposed were appropriate and were delivering the outcomes that met the objectives of Victoria. So certainly I think there is potentially a role that the community could have played in the code. I would question whether the broader community is actually necessarily even aware that there's been some pretty fundamental changes to the residential code that applies across the state. But in the case of those first two amendments, as Mark said, it's entirely appropriate that happens without the engagement of the broader community.
I'll make some sort of high-level comments about engagement and advice and expert opinion, and there is an interplay here between the state's interests and what happens on the ground, and we'd always understand that there's a continuum between where the state has an objective or an aim which is really important, and the ability of a local community to, say, frustrate that aim or resist that aim. Now, when it comes to these matters, the opinion of the question is has the state expressed its interest in sufficiently clear terms to warrant not engaging with the community to the extent that it should through normal principles. So there's just that issue around clarity on that matter. And then the other thing is that good planning practice is a partnership between the state government, councils, their communities, and that's often expressed through good state guidance on how to deliver planning in place. So as planners, we're all used to looking at the guidance that the state government provides, because it's expressing its interest in outcomes in place by the guidance that it provides. And if it says that we want to focus development in activity centres, we want structure plans in those places, here's how we see those structure plans, how they should play out, and here's the evidence you should generate, and here's the engagement process with the community, and we know that the state has those sort of guidance in place. So this interplay between state and local and community, I think, is important, just as a
It seems to have missed.
Okay, we'll just leave it there. We'll come back, Mr. Davis, Mr. Batchelor. Oh, Ms. Watts, sorry.
Thank you, Chair. Can I thank you all for your opening remarks and also your submission and for being with us today. I have a few questions, but perhaps I'll start with you, Mr. Shepherd, if that's all right. First, I wanted to ask about the impact of urban sprawl, particularly noting that Plan Melbourne, now Plan Victoria, set a target of 60% of new development within established areas and 30% in greenfield and new suburbs. I'm interested in the organisation that you represent and their view on that approach, and if you agree with that approach from a planning perspective.
So 70-30 is the
70-30,
split that's sought, and that's been in place for a long time. And yes, VPLA, generally speaking, supports that policy. There are very strong environmental, social and economic reasons to encourage a greater proportion of infill development than growth area development. The challenge with it is affordability. Fundamentally, it's cheaper to build housing in growth areas than it is to build housing in infill areas. Not just the housing, but the infrastructure that goes with that. Of course, there are a whole of lifestyle costs which need to be taken into account too, and we hear frequently, don't we, in the media about people who are living in a growth area, perhaps because it was the only way they could afford to get a foot on the ladder, and so they're stuck without local services to the same level as one would find in an infill area. And that's where more compact forms of infill development can plug that gap. So if we can find ways to deliver more townhouses and more apartments within infill areas, they are more affordable than a house on a, they're not really quarter acre blocks anymore, of course,
No,
but
not so much.
600 or 700 square metres, as
Yes.
they typically still are in the, inner and middle ring suburbs. They're expensive. Most people can't afford those. And so one way that planning can contribute to this is by setting the planning controls to encourage and incentivise the development of more compact forms of housing, as well as still providing growth area housing so that that choice is available.
Yes. Ms. Keddy, do you have any additional remarks or yourself and PA on that one?
P is very much supportive of the focus on the 70/30.
I'm just kind of interested then in about urban sprawl and the ultimate impact then on communities, not just health and well-being, but also on agriculture and environment, on continued urban sprawl, and that's really what we're trying to address here. Do you have any, from a kind of planning perspective or research or environmental law and others, that you want to contribute on that? Because I
Go on, Pat.
think that's going to come up a bit.
Yeah, look, just to reiterate the point, planners have dealt with this issue and grappled with this
That's
issue
right.
over decades. We understand the trade-off, the challenges, the constraints, the issues around urban sprawl versus consolidation. And one of the most important aspects, I think, which Mark alluded to in his opening comments, is about the economic, and it's the issue of cost savings from containing the outward footprint of the city, but it's
Yes.
also very important in terms of access to labour markets. Because what we see as the city sprawls is further and further distance to the concentrations of jobs that exist in the established parts of the city, and in particular in the centre of the city. So the further you go out, the further you are away from those jobs. So there's a fundamental issue around productivity, sustainability, and livability from this matter. But as Mark points out, there's also a challenge there. And again, just to make a comment about these reforms, what we're in here is we're still pretty early days in terms of trying to get this infill development happening. So we're pretty easily sprawled. We've done that for 100 or so years. We grew our cities outwards, and we could cut up the farms as we grew our cities. And now what we're doing is, what's that?
Melbourne 2030, I think, was 2002.
Yeah. Anyway, the point is that these sort of reforms are adding to the mechanisms and the tools which we're trying to develop around this compact city agenda.
I'm just also thinking about the other benefits of infill, and you've talked about labour market, but is there other points that from a planning perspective we should be thinking about when promoting infill development?
Well,
Apart from access to labour markets,
we should certainly be thinking, and again, Mark's pointed to this about sustainable transport and what the mode share is. You could argue that there's not a lot of focus in some of this work about maybe reducing car reliance, for example, because that's going to be part of the equation. So if we'll be not necessarily achieving the objectives if we've got car ownership at the rates that we've currently got it, and car usage at those rates. So certainly mode share and integration with public transport is a key aspect that we as planners are interested in.
Look, there's a whole
Heaps.
we
could talk all day
we
on
could
the
talk
subject.
all day on the benefits of
Yeah,
of
okay.
We've got about
infill.
6 seconds left.
Keep going.
But things like the impact on agriculture, food production,
Yes.
the impacts on the environment, those are all things that are better served by a better balance than we have been achieving between infill and urban sprawl.
Thank you so much.
Okay, we're going to keep moving. Okay, and Ms Mansfield.
Thank you, Chair, and thank you for your submissions and for being here today. I wanted to touch on the issue of affordability. in your submission, the Planning Institute submission, you indicated that one of the improvements that could be made would include an actual requirement for affordable housing. Can you expand on that?
Sure. So we have an adopted position paper that says that a planning system should play a role in the provision of capital S, social, capital A, affordable housing. We support we haven't nominated what percentage it should be or what exactly rate, but we support a mandated contribution through the development process for social and affordable housing. So that's a key point, and we haven't delved into the extent that these changes would address affordability. We can go there to a certain extent if you want, but that's our main point, is that we support a mandatory contribution towards social and affordable housing, and we haven't seen that in this set of reforms. But I do make the point that Plan for Victoria has an action, which again is to consider this issue, and so we see that as encouraging.
Okay. There was a witness last week who indicated the last hearings that this was potentially a missed opportunity to include something more than essentially a discretionary affordable housing contribution. Do you think that the planning scheme amendments, could be improved as they, the ones that we have before us could be amended or improved to include that affordable housing requirement?
Look, every year that passes that we don't have one is a yet another missed opportunity to have a mandated contribution, and we know that the earlier you signal the requirement for a social and affordable housing contribution, the greater the opportunity the market has to adjust and to for developers to factor that into how much they want to pay for land. The point is made that every opportunity that should be every planning reform that occurs without this introduction of a mandatory contribution to social and affordable housing is a lost opportunity from our perspective.
And a significant amount of criticism, I guess, of some of these changes has been levelled at VC267. Do you feel that it's possible to make that, to improve on what's before us, or do you think it would be better to start again?
Look, I think there's always opportunities for improvement. It just depends on the level of commitment and the scope of those improvements that you're prepared to commit to. There's no barrier to amending or revisiting the framing of any amendment. So the scope of changes and improvements that you could make are open and open to the members of this inquiry.
And if I can just add to that, I think there are very significant risks in abandoning it in terms of the confidence of the development industry. So there's already a challenge with that in Victoria. We hear that developers are moving to other states because the environment is more comfortable for them. If we abandon the townhouse code, that just sends a message that the planning system can't be relied upon. So I think that's a very important factor that needs to be taken into account here.
Okay, and so if that's the case, what are the key things you would seek to, if you improve really around that amendment?
I think there's a few really critical ones that we would encourage consideration of. I think the first one is the mechanism that's been adopted in terms of turning off clause 65 is certainly a significant concern to the Institute. That's what disallows the consideration of various hazards in particular that's of concern. We're also very, from Pia's perspective, one of the disappointing things about some of the reform has been its focus purely on housing. Climate change and how the planning system responds to climate change is a really core part of our advocacy and a core area of interest to our members, and certainly it does feel like responses to that have not been properly integrated in terms of the reform. The focus has very much been on the quantity of housing that we can provide, as opposed to whether that housing is climate resilient, supporting Victoria's energy transition, etc. So the ESD space, the standards that we would like to see would be significantly different to what we have at the moment. And also landscaping, we are deeply concerned that the landscaping outcomes from the code as it's currently drafted will be very poor, and so we would really like to see a shift in terms of those. So those would probably be the three critical parts of the equation.
Yeah.
Okay, thank you very much. Mrs. McCarthy.
Oh, thank you, Chair. Mr. Fincham, you said that and you've said here, the national peak body for urban and regional planners. What consultation did you have with the government before these amendments took place?
So, can't log it exactly, but we certainly provided 2 submissions to the activity centre reforms, that package of reforms that came out, including the draft controls for the built form overlay and the
walkable catchment
and was
zone
called
at
the
the
walkable
time?
catchment zone at that point. So we provided a considered submission. I suspect
Did the government take your advice?
I think there was some modifications, but probably not fully. On VC267, we provided a submission on. We were invited to provide a submission on a draft paper, and we would say that most of our, we didn't get a response particularly, or a direct response on how a lot of those suggestions or recommendations from the Planning Institute were addressed.
Okay. You talk about a mandatory contribution to social and affordable housing. Would that be another tax?
No, it's a contribution to social and affordable housing.
Who from?
We would expect that if that's levied in a sensible way, flagged,
On who?
flagged into the future for 2 or 3 years hence, then developers or landowners...
So levied on developers?
No, levied on the cost of housing, which developers would be able to factor into their development
Okay,
equation.
so it would be a tax levied on developers that you would say they could recoup from the cost of the
land.
product?
The cost of the land, not passed on to the cost of the housing.
At the moment
passed
there are
backwards
about
to the
15
landowner.
taxes on developers, which is leading obviously to the cost of producing a product, and at the moment there are thousands of houses ready to be built, but nobody will build them. Permitted councils have approved the plans. Developers won't build them because the product won't be able to go to market. Nobody will be able to afford them because of the state government taxes, charges, regulations, overlays, everything else that mean these products do not go to market. So this whole issue is predicated on the fact that there is a housing crisis created by this state government. You're proposing potentially another cost in the development process.
I think the point about the contribution to social and affordable housing isn't particularly relevant to necessarily to what you're considering at this inquiry. So we haven't addressed that in detail in our submission, and we don't propose to make any additional comment on it.
What about this impact on agriculture that Ms. Keddy went to? The greatest impact on agriculture at the moment is the advent of transmission lines crisscrossing this state to deliver renewable energy inside the tram tracks, basically. Do you consider that an issue for agriculture?
It's not an issue that's relevant to
But
the
you've
terms
talked
of the
about
inquiry.
the impact of agriculture on housing development, including housing in an area.
In
let's bring it back to that
the
particular
context of the extending of urban areas out into agricultural areas, which I think is relevant in terms of why things like supporting infill are important. So
What
in that
agricultural
context, yes.
areas have been affected?
There's numerous agricultural areas around.
Can you name some?
Out to the southwestern suburbs, there were some of the most productive agricultural areas. Werribee was a well-known.
Werribee is still a very productive horticultural area?
Sure. I'm sure there's still some productive land there, but and again, I'm not going to get into a debate around.
Well,
I think we're probably getting on the fringe of our
you make these comments. You've got to be able to justify them. You talked about all these planning amendments, Mr. Frensham, being in the public interest. What public interest has been consulted in this? Local councils haven't been consulted. In fact, they've been told they're going to have to pick up a huge amount of the infrastructure costs if these proposed centres go ahead.
We're not here to comment on the process of community consultation and local council engagement. We're certainly interested in our opinion and whether it's been sought as experts in this area.
Doesn't seem to have been.
And we've expressed some reservations about the extent to which we have been consulted and the broader planning fraternity, if you like, who would be responsible for interpreting and applying some of these controls. So we can certainly see a better process that could have been
because
implemented
third-party
in relation
rights
to
have
that.
been absolutely dismissed.
Well, we've outlined the sort of principles where we suggest that it would be reasonable for third-party rights to be removed, and we're pretty clear about those principles.
So you think third-party rights should be removed?
No, we've made the point that in relation to VC267, we're concerned that doesn't necessarily meet the tests that we would see for the removal of third-party appeal rights.
Thank you.
Yeah.
Thank you, Mr. McArthur. Thank you. Mr. Batchelor.
Thanks, Chair, and thanks everyone for coming on and giving your evidence today. Mr. Shepherd, earlier you talked about some of the problems in the current system and the unknowns in the current system that are leading to risk and drivers of risk and drivers of cost, and that they are factors in driving up both of those issues. What are some of the features of the current system that are contributing to increased risk and increased cost, in your opinion?
By current system, do you mean
The
res
system
code before March?
Before March.
Yep. Okay. The discretionary nature of the controls and the performance-based nature of our planning system means that there's very little certainty when a developer buys a piece of land, what they're going to be able to achieve on that piece of land. There's very little certainty how long it will take them to get a permit, if they indeed get a permit, and there's a link between that length of time and the cost. So in a situation where, let's say, for example, the council officers decide that the application is appropriate and the council laws endorse that, but a local resident objects to that decision and that is appealed to VCAT, that can turn what might otherwise have been perhaps a 6 or 8 month process into an 18-month or 2-year process. And that's a process that usually involves lawyers, involves expert witnesses, all of whom cost a lot of money, and of course simply the length of time if the developer has borrowed money in order to buy that piece of land and in order to fund all of that, the services they're receiving, that's all adding up in cost. And of course that cost got to be paid somewhere. The developer's already bought the piece of land. So unfortunately, the only place that cost can go is into the cost of the product at the end of the day. Plus it slows down the delivery of that housing.
So it's fair to say that the feature of the system that existed prior to these changes coming through did have elements that were driving increased costs of
Absolutely.
housing in the system. Ms. Kitty, you talked about previously some elements of the code, the res code, that needed reform, and your submission goes to the question of the challenges that things like neighbourhood character in the current scheme have had in as barriers or factors that are inhibiting better development. Can you expand on that a little more for us?
I think, firstly, we'd agree with Mark that some of the uncertainty in the system has created barriers that have added to cost. I think the key thing really is that those things that the development industry needs are they need certainty around yield, so certainty around the envelope that they'll have in terms of what quantum of dwellings they can provide within that, and they need certainty around the time frame. So I think that's a really important distinction to make, that it's not necessarily the details and some of the elements that have come out of the code probably could have stayed in the code if we focused around providing certainty around the envelope and the timing. Those things you can actually provide and yet still retain perhaps some of the elements that have come out of the code under VC267. So PIA has certainly, and through some of the process of engagement with the state government on this, we have indicated that we do support a move away from the emphasis on neighbourhood character in some of these areas where we really do want to see more housing. It has certainly played.
Why? What's been the problem or the barrier in the former system?
So
on that element,
neighbourhood character. I think one of the challenges is the way it's been integrated into all sorts of parts of the planning system, and that's perhaps, and also in terms of how the guidance that's been provided to council about what they actually have to consider when they're making decisions, and so that's perhaps put a weight on neighbourhood character that might not be appropriately balanced with some of the other outcomes we want to see. So when decision makers come to look at making a decision, they use the words that are in the schemes, and there's a lot of words around neighbourhood character, and there's a lot of detail around neighbourhood character, and so sometimes that can mean that there's a disproportionate consideration of neighbourhood character, perhaps to the extent that some of the other objectives are not fully considered in terms of, the locations that we're talking about, where the net community benefit of providing those additional houses might actually have a greater weight than the protection of that character. So we don't get really clear signals through the zones, and certainly you could have a much broader discussion around how the zones have been applied, and I think VPLA might have mentioned that in their submission, but certainly the way our residential zones are framed doesn't help that either, because it means that there is a lot of emphasis on neighbourhood character. If you do a word search, if you do a word, and I think we would very much draw a distinction between good design outcomes, which includes a contextual response, and neighbourhood character as it's been applied in the current planning framework.
Thanks,
Thank you. Over to you, Ms. Crozier.
Oh, thank you very much, Chair. Thank you very much for appearing before us. I'm just stunned with those last comments about neighbourhood character. Surely it is incredibly important for people who live in these areas that they have a right and a say and understand that character, as along with councils who've been shut out of this process. And we've had letters, I've raised it in the Parliament, I raised it with witnesses last week. But if I could go to you, please, Mr. Fensham.
Sure.
You said, you referred to normal principles. I want to understand, in relation to this process around these amendments, and the importance of state, local and community being involved. Have normal principles been disregarded by government in this process in relation to these amendments?
There's been some haste over the process, and we understand that that's a response to a housing crisis as it's described. So we certainly understand the government wanting to make reforms in this space. And in relation to the activity centre work, as I say, the conclusion could have been maybe a little bit better, but we understand the need for the effort and the intent behind that, and so as we've summarised and concluded, we don't see them as fatally flawed. we certainly are disappointed from our perspective in relation to the consultation or engagement with us as experts on VC267.
Okay, so you've said that there is haste by government and that you've been disappointed in that. And Mr Shepherd raised some concerns around modelling, and more modelling could have been done in his submission. Do you agree with that in relation to more modelling and the impacts to neighbourhood character, the tree canopy, all of those risks that have been highlighted in Mr Shepherd's submission? Do you agree in terms of what government have done here? They have moved too fast and cut community out and cut councils out in having proper assessment and oversight of what the government's intentions are.
Jane might talk to that point.
In terms of the modelling and testing that's been done, certainly we have outlined in our submission that we think that particularly VC267 could have benefited from some additional modelling and testing so that those outcomes are more fully understood in totality.
How long have they had to be considering all of this?
I couldn't answer that question. You'd have to talk to those within state government.
And there for 11 years.
11 years. Right, 11 years. Could I just move to Mr Shepherd's submission? Thank you very much for that. And to go to Mrs MacArthur's point, in your submission you speak of further measures could be undertaken to meet housing needs. And these include reduced taxes and charges related to development to improve feasibility and therefore supply. And I think it was Mr Fensham, correct me if I'm wrong, that said that developers move interstate because it's more comfortable. Surely there are massive issues around the area around taxes and levies and charges and regulation that Mrs MacArthur was making, which you highlight in your submission. So which taxes are you referring to and levies, or do you agree that all of those impacts are a massive barrier for developers to be able to undertake the work that is expected by government?
First, I just want to correct, in case Mr Fensham takes offence, it was actually me who spoke about developers moving interstate.
Beg your pardon, that's why, thank you for correcting me, I wasn't sure.
Look, I'm not going to speak to specific taxes and charges because I'm not an expert in that. And I want to emphasise too that they are just one factor in the current development equation which is not working.
But a significant factor?
Well, yes, it's a significant factor, absolutely. The other thing I want to point out is that the feasibility of development changes over time with the economic cycles. Right now, it's really problematic. And so there's not a lot of development happening, principally for those economic reasons. Taxes and charges are one factor in that. However, the government does need to receive contributions from development in order to pay for infrastructure. So I don't want you to think that I'm suggesting they should be wiped. What I am suggesting is that in times like this, maybe there is an opportunity for perhaps a temporary unwinding or relaxation of some of those charges in order to stimulate development, which might then be returned when the economic cycle changes.
Are you referring to the windfall gains tax that could be deferred?
That's one of them, but there are many.
And what are the others that could be that you...
I couldn't answer that.
But there are many taxes that could be deferred.
There are quite a number of taxes that impact on development.
Okay.
There's at least 15.
I want to go to the issue around the government land, the surplus of government land. I think you've all mentioned that. Fisherman's Bend is in Mr Davis's and Mr Ryan, Mr Birch's, all of our electorate. It's there ready for development. Why is government stalling on that, given we have this housing crisis and this issue?
Well, most of Fisherman's Bend is in private hands. It's not government owned.
So how much is in government hands?
I couldn't tell you exactly, but the vast majority is in private hands.
But given that has been on the horizon for many years, is that a failure of government to be able to look at that parcel of land and get this housing issue partly resolved through the supply issue?
The piece of land that the larger piece of land that government owns is not zoned for housing.
Right.
Can I make a point on that one, just to follow up on? So there's been a little bit of to and fro here around whether the costs of development and whether the tax and charges are an inhibitor to development, and certainly, obviously, if those are removed or they're modified, then the development industry can proceed with more confidence, given the prices that they're able to achieve. And this is maybe, I've noted who's appearing later in the day, and I'm sure there'll be all sorts of debate about the economics of planning and affordability. But generally speaking, the prices are set by the broader market, and the ability to pass on those taxes and charges is a difficult thing, or an impossible thing actually, given that the prices are set broadly.
Mr. Davis.
That's right.
Mr.
That's the point. Is David, that it'll stall or delay development which would otherwise occur. So I think it's worth pointing that out. And just in relation to Fisherman's Bend, and broadly speaking, one of the things which we don't focus on a lot here, but the Planning Institute talks about in general, is that land use change has to be accompanied by infrastructure provision to catalyse development as well. So the Fisherman's Bend problem has been that perhaps we haven't seen the signal to the market provided by a program of infrastructure investment to actually encourage that development. But also
we've got SRL.
Yeah, but so it is important that that those two things go hand in hand, as infrastructure provision with land use change, and of course the intent of a lot of the government's changes, particularly the activity centre work, is appropriately targeted to places that have existing services and transport, but that it doesn't mean that there shouldn't be a follow-up contribution towards upgrading or additional infrastructure in those places to give the market confidence in their investment in those places.
Okay, thank you. Mr. Berger.
Thank you, Chair, and thank you all for your submission this morning. Patrick, I'm interested in your 9 points, sorry, in particular the second point where you said the changes are important and you supported the intent. But I want to go back just 1 point before that, and you talked about your strategic focus. I just wonder if you could elaborate a bit more on what that means.
Well, the origin of these reforms is in the housing statement, from a few years back, where the government acknowledged that there's a really big problem with planning, with housing supply. So there was a range of ideas or dot points in that document, and these reforms are a product of that effort. So perhaps again, we see consistency in the long-term planning aspirations for a compact city, for activity centres as a focus for development. So we see the line of sight from that to the changes which have resulted in 257 and 274. So they're consistent with that principle of development in good locations. But again, we come back to VC267 as being a little bit jarring in this context of a strategic focus of development in well-located places. So it's that piece of the jigsaw which we don't necessarily see that strategic or that link, if you like, back to a strategic agenda.
I might just add to that, because one of the things that's really important from a planning perspective and the role of a planning system is that planning balances a whole range of different things that the system needs to do. So the planning system is not just about housing, and I think one of the challenges that there has been is that the housing statement has been a response to the housing crisis that we have at the moment, in terms of
there's 8,000 beds going begging in the CBD.
So
nobody wants to go
Mrs. MacArthur, please.
Well, we can put housing crisis in if we want. So it's been a response to a particular issue, but it's been a response to one issue amongst the many that planning deals with. And a good example from Pear's perspective is we are also of the view that we're in a climate crisis at the moment. So having a response that looks at jobs, that looks at the climate, that looks at housing, that's what planning does as a role. And unfortunately, we've had a housing statement that's driven a lot of the reform, and that might mean that some of the other aspects of how those different parts of the planning system work together have perhaps had lesser attention than they would under a broader strategy.
So does it then follow that these reforms encourage more homes and development around transport services and things of the like?
As we said, the activity centre, the VC257 and 274, certainly the enabling of that those tools provide is very much aligned with that. We've raised in our submission concern that 267 in turning up the dial, so to speak, on development on every residential lot across the entire state. So that includes township-zoned land in small regional settlements that have no services and facilities and no discretion now available to councils to balance those outcomes. That certainly is something that doesn't quite fit with those overarching balancing that the planning system normally plays.
And Mark, in your opening, you talked about the positives that these amendments are there, and you more particularly spoke about the diverse housing. Can you elaborate a bit more on what that means?
Yeah, so what's tended to happen in the infrastructure-rich parts of Melbourne, the really well-located suburbs, is that there's a bit of a homogeneity about the kind of housing that's there. It's largely detached housing. And so that means that it kind of locks out significant cohorts of the community who can't afford to live in those really good locations.
Get a flat in the CBD.
And so what these amendments are seeking to do is to diversify that mix. Now, it's not going to fundamentally change it, and most of the amendments are focused on, as you mentioned before, the areas immediately within activity centres or around them or close to good public transport. So it's certainly not at that higher density affecting the vast majority of the residential neighbourhoods. In fact, what it's doing is it's protecting the vast majority of the residential neighbourhoods by focusing that high density on the areas immediately around stations and activity centres. But what that will do, if it's effective, is to introduce a wider diversity of housing types in those areas.
Can I just add a little point to that? We know, and you'll probably hear again later in the day, that the sort of development that's envisaged under VC267 is the townhouse sort of format, and that is a lower cost development product than an apartment development. So again, there's a worthy intent there, because getting more of that stock into the market is part of the diversity issue. It'll address some of the barriers to the property sector from developing in infill areas. So there is an upside from that point of view. But our concern is that it's a pretty well one size fits all for all residential zones. So the Planning Institute would have preferred to see this as a more spatially defined approach, and also with those subtleties around how it might be amended that Jane's alluded to, and in particular a little bit of a dialing down of the deemed to comply or the mandated or the deemed to comply aspect of it. Yeah.
Jane?
I was just going to say, and I think that there is the opportunity to potentially differentiate between those well-located areas and areas that are not well-located in terms of access to services and facilities. I think a really important point around that is I think both Mark and Pat have made really important points about this type of development, so townhouses, and we'll leave aside dual locks because they'll probably come out of the planning system altogether, but 3 to 10 townhouse type developments are likely to be a large proportion of what we see in the coming years in terms of how we get that diverse housing stock in the areas that we want to see it. What's really important though is to recognise the role of the planning system and the code in terms of actually setting a minimum standard and our minimum expectations. And I'll go back to the point that Pat was making, is that we have to be satisfied. We don't need to worry about, excellent architects doing fantastic work in inner cities. But, you know, to a degree, the planning system just needs to kind of get out of the way of those developers. And there's a lot of developers doing really good work. So that's great. We get out of the way of them, and things like the Grand Designs Fast Track Pathway, they're really great initiatives to work and to do that. What the code needs to do is make sure that those developers who perhaps take a much shorter term view and perhaps don't have the same, are maybe more yield driven, that they meet minimum standards that we are happy to see across these areas. And we are concerned that the minimum standards and the detail of those minimum standards under V6.7 perhaps are not fully understood, and that the outcomes are perhaps not what we do want to see across this typology. And that's actually really important, because we want people to want more of that housing, and we want communities to want more of that housing, because that density brings dividends to everyone. When you get increased density, you get more services, you get more facilities, and those things become a critical mass. So we want to make sure that density is provided in a form that when someone kind of pushes the boundary as much as they can to get the most that they can from those minimum standards, that we're still really happy with the outcome that we're getting on the ground.
Okay, we'll leave it there for that. Oh, now we've got a few minutes left, so we just might have a few quick questions, and we'll look for some quick answers as well. I might just start. I guess a proposition's been floated about a potential selective revocation of part of 267 to remove the exemptions in clause 55 of the VPP, effectively addressing questions around clause 65 in the decision guidelines and section 60 in the Act. Could I get your initial response to that as a proposition?
Maybe. Jane, do you want to... Or Mark?
I'm happy to speak first. I think that's one of the issues that's been raised, and perhaps unexempting clause 65 might be a positive way forward. We need to be careful not to throw the baby out with the bathwater here and get rid of all of the exemptions, which are doing a job. But we mustn't forget either the other fixes that we think need to be made, although they could be made down the track.
Thank you.
That seems a sensible approach. Certainly, that is one option. We would very much encourage that there are further changes made, but those don't necessarily need to be as a revocation. They could be made as a commitment to. And you would want to see a meaningful commitment to making those changes and incorporating those other aspects that both VPLA and PIA have raised in their submissions.
Terrific. Thank you very much. Mr. Davis?
I want to ask about this suite of measures, if I can call it that, because I don't think they can all be fully disentangled. I think we want to do that, but I think they're all going to have a pile-on effect, if I can put it that way. What will it do to heritage? And I'm particularly concerned, many of our inner city areas, our middle ring suburbs have got wonderful heritage with statewide heritage protections, council layers, significant, I'm looking for the word, not vistas, no. Sort of...
Landscapes?
Yeah. These will actually weaken those protections and put those heritage layers in conflict with some of the new points. Now, the effect of this will be to significantly weaken the heritage protections in a number of areas, I think is the truth.
I think one observation that I would make is that growth and heritage are not two things that are mutually exclusive. Certainly, the protection of heritage is a really important value in terms of even just the interest of our streetscapes and the diversity of our streetscapes, let alone the value that they bring.
But let me just get
Sorry,
very...
Mr. Davis, sorry, we've only got time for one question. I'll let them answer.
you can balance, and there's examples all across the world of where places have heritage and they have growth. It's a matter of how that growth is accommodated, and certainly I think there's scope within our system to do that well.
But these don't do it.
Mr. Davis, sorry, we do need to share out the available time. Sorry, did you want to make a comment, Mr.
No,
Shepherd,
let's
in
move
reply? Okay, thank you. Mr. Batchelor?
It seems to me that the evidence you've collectively given is that wholesale revocation is not the right approach, but there are improvements that we could make to the amendments that have been implemented. What do you think the top 3 changes that we would want to make in the iterative evolution of this process are?
I would actually repeat the 3 that Jane mentioned before. The ESD provisions, the landscaping provisions, and what was the third
65.
one? Oh, and clause 65.
65 taking account of the neighbourhood character stuff?
No, not and I think that's actually probably a really important caveat to make if that's the interpretation that's been taken. When we talk about clause 65, we're not talking about neighbourhood character. What we're talking about in terms of switching back on clause 65 is actually the consideration of all of the other things that enables. So things like where we know there's flood hazard but we don't have an overlay, things like potentially contaminated land, things like other environmental hazards that now are very problematic in terms of the assessment process. So switching on clause 65 without the neighbourhood character considerations would be one. ESD, absolutely. PR is of the view that where we were before needed to be significantly improved if we were to have climate safe housing that contributes to energy efficiency. We've gone backwards when we needed to go forwards, and certainly landscape, the outcomes that we see under the current controls are not appropriate in our view.
And just to reiterate, we've got 4 of the lighter touch changes. So reintroduction of clause 65, scaling back of the proposed standards to retain more conservative standards, which we haven't actually mentioned, so that'd probably be more of a stretch, but something to consider. The new standards relating to landscaping and siting and design for solar orientation and energy efficiency are in there, as well as our list.
Okay, we'll leave it there. Ms. Mansfield.
Thank you. Just wanted to touch on the subject of infrastructure, and just briefly, if you can provide, you've mentioned that there's been a failure to, I guess, appropriately plan for necessary infrastructure. I know transport's been considered, but other forms of infrastructure, and whether you've got any comments on how that could be better considered in some of these planning changes that are being made.
Well, I think it's pretty fundamental. As I mentioned before, we're redirecting growth into the established parts of our city according to a pretty well accepted planning norm. And we've had a long tradition of, even in greenfield areas, having pretty detailed infrastructure plans, even though sometimes the community facilities are slow in coming. There's usually reasonable plans about what we're going to provide. And we've just seen, I think, a lack of whole of government thinking around supplementary additions to the schools infrastructure, to transport infrastructure, to and then even to some of the big state infrastructure coming down, and then into the local infrastructure. What does the open space network look like? What's the additional vegetated areas going to be? What are the new streets and lanes which are going to provide a more walkable environment? So we're really of the opinion that those things are absolutely critical, as well as the changes to the planning controls and what's permitted through the planning system, that there's a dual consideration and a parallel consideration of those infrastructure issues, because we want to see livable, quality places.
Can I just add quickly to that, and Pat may disagree with this, this is Vipler's view, that the amendments that are before you aren't the ones causing that problem. It's the application of those instruments through other amendments where there needs to be coincident consideration of infrastructure.
Yeah, I do agree.
So are you talking GC252 there?
Yes, that would be one of them.
Okay. Okay, and I think that's it for time. Could I firstly thank, on behalf of the committee, both organisations for your very thoughtful submissions, and also for attending here today, I know on what was very short notice. So we are really appreciative of, no doubt, the diary bending you've had to do.
Could I also make the point, we're very grateful to the committee for the extended period that we were granted here, so thank you very much for that as well.
Thank you.
That's respectful of our positions and our profession, so thank you.
I think it was very well spent, so we appreciate it. Could I just note that you'll receive a copy of transcript for review in a very short time frame. Everything's very short on this inquiry before it is published on the website for any comments you might make. I would just note that the committee will now take a break for 10 minutes. We'll be back about 10:40, and we'll go from there. So thank you again, much appreciated. And